There's been a declaration of Section 194 of the Penal Code that creates criminal defamation unconstitutional as it limits freedom of expression. Now, joining me in studio is Maina, Director of Article 19 Eastern Africa. Thanks for making time. You know, when we talk about that, people always imagine that this is too complicated. What essentially does that mean to the common mwananchi and to journalists as well?
The declaration of Section 194 of the Penal Code to be unconstitutional means three main things. One is that Kenyans and journalists would no longer be sued, would not face criminal charges in the event that somebody feels that they've been defamed, that there is only now one route, and that route would be the civil option, which does not push the journalist or any citizen to a jail sentence or the odious indignation that comes with criminal trials. So that's one thing. The second thing that it meant was that the judge reiterated that in real terms, this provision of the Penal Code has been used to criminalize journalistic work, to not allow citizens who were desirous to hold public officers or public figures to account. It made it very hard for people to get information, because anytime a leader would think that you're about to begin scrutinizing them, then they would throw, using the office of the DPP, this trial against you. And at best, then journalists would censor themselves, or would just shun controversial public issues for fear of being arrested. The third thing the judge reiterated was that a sentence of 2 years in jail is quite disproportionate to just defaming someone. And so the judge was reiterating that where in Kenya, for instance, there is a Defamation Act which gives an alternative civil remedy to this person, we ought not use meager resources of the state to cure or help restitute a reputation of a person, because that is a private matter and it ought to be dealt with privately.
All right. Now, the counter-argument to that is that then it opens the floodgates whereby anyone can say anything about anyone with very minimal repercussions.
The truth is to make people understand that the civil part of defamation remains intact. The Defamation Act remains fully in force. So it's not true that people would remain reckless with whatever assertions that they make. But all that the court is saying, and those of us who are in court challenging the constitutionality of this provision, was that it is misused by public officials or public figures who have a way of moving the police machinery and the office of the DPP for purposes of removing themselves from scrutiny. The idea that a criminal defamation suit will restore your reputation is in itself fallacious. So when that happens, you would get the notion in Kenya that we all say ili liwe funzo kwako na wengine kama wewe.
Yes.
So the person who's doing this is not doing it with a view of restoring their reputation, but it is just to send a chilling effect to any other person who would have wanted to hold them to account. And you would see the questions here, the two people who had been sued, who we joined to challenge this. One was just a lady who was asking the father to the baby to take care. And that's all mistake she had done, to say that you need to be responsible for your offspring. And yet we have a provision that instead of you saying, I am the father or I'm not the father, or this is going to be my responsibility, you use a criminal provision in law to ensure that nobody holds you to account on those parental responsibility. So I think for me it's a great day that people who think they have a reputation to keep will have to go through the rigors of civil law. They would have to show that, one, they have a reputation to keep, and two, that the allegations made by all other people are untrue and substantially untrue, They would have those defenses so that when they get any damages, they will be well earned, as opposed to using the criminal justice system to intimidate journalists, to intimidate public interested citizens who want to question certain actions that those individuals may have taken in the course of life.
And many argue that this essentially supports the journalists more than people who may be aggrieved in one sense or another.
Yes, you may argue like that, but Jacqueline and her counterpart were not the journalists. These were just individuals going on their daily life. So one was charged in Kwale, another one was charged in Nairobi.
But the complainants would feel like this is against them.
Yes.
So it's one-sided.
So that's the thinking. But again, we had perhaps any other person who would have thought that this provision is necessary is to remind ourselves that the section on criminal defamation in our penal code, which was a 1930 law, amended several times to include a few other offenses, but these remained intact from 1930. What was the intent of the law when it was put in there in 1930? You would notice that we have provisions like defaming a foreign prince and a foreign ambassadors and all those. So meaning that at that time, the law was not even protecting the Kenyan, as we know. It was only there to protect foreign princes and kings. And so that as a country, independent country, we've kept that law intact 50 years down the line. Yet at independence, we were saying these are the bad laws that were being used against us. We will ensure that we reform. Then this is 7 years since the Constitution came into force, and we haven't changed that. So one of the clear things is that there is a duty on to the Attorney General and on to Kenya Law Reform Commission to clean the penal code of those provisions that may not sit in conformity with the Constitution, even though the Constitution allows them to continue existing. But what we've seen in practice, the implementation has gone on as if the Constitution never came into force. And that is what we were challenging, that can they continue to sit in conformity with the Constitution? The answer was no, and that's what the judge arrived at. So yes, those who are complaining have a responsibility in the event that they want to follow the law to appeal in 30 days. If they come to court, we will still be sharing more on what we think. But there are many other Kenyans who are charged under this provision. I think it's important for them to know that the section has been declared unconstitutional, and therefore any other criminal charges ongoing under the same section ought to be annulled.
Hold that thought in just a bit. We're coming back to finish up this discussion, but let me let you know what's really happening right now as we speak. Former IBC Chief Executive Officer James Oswago and Agent Trevor Ombija are currently before the Anti-Corruption Court in Nairobi over the Chicken Gate scandal. The two were arrested this morning by EACC detectives. There was drama at Integrity Center as Oswago loudly protested as he was led into a vehicle to be taken to court. Oswago is alleged to have received millions from a UK printing firm to skew award of a contract.
But don't push me, I'm going. Don't push me, I will go.
Then you go.
Yeah, I'll go.
There
is no single investigation in this. I tell again, there is no investigation in this. A chief executive officer cannot be responsible for all the ills of society. I said no.
Henry, let's finish up on this. Knowing the justice system, how do you intend the implementation of this is most likely going to take quite some time, or is it going to be instant?
It's never instant, given the nature of our legal system. In other jurisdictions, the Office of the Attorney General and the Registrar of the High Court would extract the decision and communicate to all courts so that they do not continue to entertain any other matters under that section. But that seems never to happen in our situation. So the individuals under prosecution have a duty to bring to the attention of the judicial officer who is managing their court session where they are charged, that this has been dropped.
Yeah.
So that tends to be a very nebulous situation, that you will have people charged who may not know. Sometimes you will also have police officers who may know but would pretend not to know.
Yeah.
So they would still prosecute you or arrest you under similar charges. But I want to really thank the Office of the Director of Public Prosecution, because now, before anybody is charged on a new offense, there is a need for the prosecutor in charge of that station to approve.
Yeah.
So that perhaps is going to be the solution in ensuring that we don't have similar new charges coming up. But those that were ongoing, I think the individuals under prosecution have a duty to search around. And I know I had 2 yesterday calling me from Mombasa,
yeah,
asking me for the decision, which I ably shared with them. So asking them that when they appear next in court, it is their duty to share with the magistrate or the judge in their respective cases that here is a decision of either a similar court or a higher court, which has already declared this section unconstitutional.
And speaking of judicial speed, what do you make of the story we just aired right now? This is the Chicken Gate scandal. The UK have already finished the investigations. We are still in the tug and push and pull with whether who was there. There's investigation still going on. What do you make of that?
I think we are a country that likes a lot of talk and less work. That's what it really tells us. That perpetrators of a corruption act in the UK were investigated and found guilty. And yet their core criminals in Kenya continued to walk scot-free under the guise that Kenya was equally conducting investigations. That for me tells us something. But 2, that there is a mutual legal assistance that we have signed with a number of these countries. When it suits us as a country, we tick the box and expedite extradition for people to be tried elsewhere. We know that a number of Kenyans have been extradited to UK, to US on terror charges even before investigations began. But where we have credible investigations on issues of corruption, we know the case of Chicken Gate, we know the case of Honorable Kemo and Gishuru, which has been pending in our courts forever. See how long it took us to extradite the Akashas. So sometimes we make a claim that we are investigating, but it is only our strategic way of slowing down the process and sometimes frustrating justice.
Some of them argue that it's a matter of not having enough resources.
I don't think so.
The
police and security agencies are the only ones who, in the last 10 years, have had their budgets increasing, sometimes to the cent that they've requested.
Okay.
So how can they continue to say that they are denied resources relative to other departments who are given 40 or less? So, and if this is one of the biggest cases, why don't we see the process of the executive saying we will focus on these big cases by concentrating our investigators, by ensuring that everything is done, by seeking mutual legal assistance from other countries that have exhausted the investigation, so that we have a closure to some of these matters, that people who are alleged to have been involved in corruption have their day in court, and the government equally has its day in court to adduce proper evidence, and we close the matter, because sometimes we tend to politicize these processes. When we get closer to elections, we see attempts or some machinations to seem like we are doing much. And then after elections, we will go into a lull and then wait for another 4 years. And the 5th year, again, there will be another rush. And I think that is wrong for our country, because systems ought to be able to work bereft of the politics of the day.
All right.
And those who are responsible must be held to account.